Hello, everybody. We're here for AHA with Amplify. We're going to let people slowly roll in before we get started. As people are joining us, I'll introduce some of our admin items for AHA with Amplify. We're really excited today that you're joining us to talk about business liability exposures and risk management tips. We know that so many of you are business leaders and finance leaders, and one of the hard decisions you make throughout the year and throughout your growing business is what should you insure and what should you not insure, and how does that insurance help you, and what's the ROI, and all those exciting business liability and risk topics that are not easy decisions for any of us to make. And generally we sit around executive tables where one person is an insurance lover and they want every single risk covered in an insurance plan for every possible downside. And then you got the cowboy in the room who thinks that $1 spent on insurance is $1 down the toilet. And someone has to balance all these approaches. And a lot of times that is you, the finance leader, for those of you in that seat, that has to come with a more balanced risk perspective. So really, really excited to spend this time with Andrea and get into the topic. Before we do that, I wanted to remind all of you that Lively Entrepreneurial Talks with Amplify is our newest and latest venture. So we have decided that apparently 86% or something like that of people would rather watch a video than read a blog. So to our great reluctance, we have a lot of chins on some videos, and there is an opportunity for you to watch Jesse and I have lively conversations about all kinds of topics that we know impact our business leader and finance leader community. So please take the time to subscribe to our YouTube channel and or our podcast on Apple or Spotify, and pay attention to those shorts that are on social media, and let us know what you think. We're excited about it. We've got a cash flow podcast YouTube video out. We've got talent just recently received. So as all of you know, we're in the business of hiring ourselves as a growing business, but we also are recruiting for all types of business. So we've really packaged the experience and information that we've gathered in the area of talent, and especially in hiring and recruiting, and put that into the podcast and the video. We've got 2 more coming out shortly, so stay tuned. There's lots happening on that Let's with Amplify, Lively Entrepreneurial Talks. It's the podcast video launch that Jesse and I have done, and we're really, really excited to share it with you. So please do subscribe. Today you're here with AHA with Amplify, and this is the format that we do webinars and events. And our next webinar, which is on the 3rd Tuesday of every month, so in May, you'll get to join us to talk about tech. So it's the one time a year that we dominate the whole video with Amplify people, and we're going to have our subsidiary Amplify Tech come on and talk about some of the best tech topics that are happening today. So please do register and join us in May. In June, we're going to have an expert come on for personal branding. Thank you so much to the many of you that gave me feedback on the article we did in the CPA magazine on personal branding. And please do take a look at that article and our blog, and join us in June when we have an actual expert on personal branding inform us about how a personal brand can make a really big difference in terms of influencing within the roles and organizations that we're happy at, and of course, in getting a new job and a new opportunity for those of you that are working with our recruiters or with other recruiters. So we're very excited that AHA with Amplify, the spring sessions are Amplify Tech in May and personal branding in June. So be sure to sign up for both. We'll take July and August off and be back in the fall with a whole bunch of new topics. I'm sure we'll also have a great live event to announce shortly, and you'll be able to join that for live CPD2. So without further ado, let's turn to Andrea and hear about business liability exposures and risk management tips. Thanks, Andrea.
And Janie, just to clarify, did everybody see the front screen already with the links?
Yes, we're
Okay,
good to see your screen.
Great. All right. Well, hello, everyone, and thank you so much for taking time to attend today. My name is Andrea Collis, and I've been a commercial insurance broker since 1989. My usual joke here is that clearly I started when I was 5, because 1989 makes me feel really old. I am a chartered insurance professional, and I opened my own independent insurance brokerage in 2008. And the reason I clarify this is that within our industry, there's a lot of insurance brokerages that are actually owned by insurance companies. So one of the ways we differentiate is that we're not required to put any type of business with any particular insurer. So all of that being said, our agenda today is it's a fairly big thing that we're going to go through pretty quickly. Due to presentation time, we've only chosen specific types of liability or negligence for businesses to discuss with you. And for each of those areas, we're going to review the types of claims collected from either our office or different insurers, and some basic risk management tips and tools. And then finally, we're going to come up with some suggestions on reviewing risk management within your own businesses. Our goal here today is not to talk about insurance policies, rather liability exposures. Do keep in mind that risk management has been kept to being very general here that would hopefully suit most businesses. And also we've tried to make it suitable for the very small companies as well as larger companies and nonprofits, depending on who is sitting in here attending. So everything might not fit your organization, but our goal here today is to give you some information to enable you, if you haven't already, to start thinking about how to assess risk in your businesses and design some internal protections and controls. Your challenge that I have for you today is to try to use this information and review and brainstorm possible exposures to your specific business with your team and your community to help protect your business at a later time. As I know, as business leaders and owners and management, it can be hard in our day-to-day with all the balls in the air to focus on these things, but a few steps forward is important. So I'm going to start off here with only 3 key definitions so that we're all kind of on the same page. Firstly, just to confirm what is injury. And for our purposes today, we're going to be talking about injury in terms of physical damage, bodily injury, mental or emotional injury, reputation damage, and financial damage. And all of this is put into the perspective of negligence or alleged negligence. So, what is negligence? And again, for our purposes, we're going to be exploring negligence as the results of our actions or our inactions for which we can be held legally liable, which of course leads to what is legally liable. And for our purposes, it's if a court can find us responsible for the damages or would likely find us responsible, how much damages might be awarded due to our negligence. So that's just our quick and dirty definitions. And this is what we're going to cover today. The common areas for liability in businesses, which we've narrowed into 4 types of areas. Mistakes in our work as a professional, bodily injury, emotional injury, and that can either be to third parties or employees, physical damage to other people's properties, and mistakes that we might make in running or managing our business. And you'll also see here on this slide, I actually kind of indicated who can be held liable for those things. We're going to start with the easier ones to work through on how to protect your business and finish up with what I feel is actually the most challenging. And one thing you're going to note is that in some cases, I've put that the owners and directors of the company can be held personally liable. This is something that I deal with a lot of time with business owners and executives, is that a lot of them feel that they can simply walk away if the company fails by shutting down the company. And in some cases that can be true, but in other areas it's not. And there are areas where our laws make owners and directors personally liable, i.e. your own personal assets are on the line, whether you're running the business or a nonprofit. And we're going to explore some of those areas in our last section. But for our first section, we're going to take a look at professional exposures. And to get us started, the first area we're going to look at is mistakes in our professional work, which causes a financial loss to someone else. And so for context, we need to understand who is actually deemed to be a professional. And that's typically someone who has special knowledge or skills or qualifications that's offering a service, and someone is relying upon you for your expertise. So that in itself is actually very broad if you think about it. So that's everyone from your CEOs and accountants to lawyers and architects, but also, you know, massage therapists and psychologists and hairdressers and fitness trainers and you name it. Oh, here I got carried away and I haven't been showing you changing the slides. Oh, my apologies. So I'll just quickly catch up. I had some definitions for injury and negligence and who is liable. And then this is our slide for common types of losses and who can be liable. So I'll just give you a second on this one because I know that this was kind of the areas that we're going to cover, and my apologies. Got a little ahead of myself there. So this is where we're at.
Questions were very clear, so we didn't even notice there was no slide.
Okay. Okay, so this is where we're at as to who is a professional. And typically there are actual definitions of this. But one qualification I want to say is sometimes someone can be held as a professional if you're simply acting or portraying that you have particular knowledge or skills in qualifications. And the reason I clarify that is that there is still real world knowledge that's there, that not everybody has a degree, but is still an experienced professional in what they do. All right. So what therefore is professional liability? Well, clearly it's making a mistake in performing your actual work or service, but it can also be the failure to render your work, complete your work, or simply omit doing a piece of your work. So again, this is quite broad when we talk about it. And so for example, if it's an architect, that would be the actual drawings and designs that they're working on. But if it's a project manager, this could be the failure to properly supervise a project or missing something when the construction was being done. For an HR consultant, it might be perhaps failing to identify a risk to be considered when terminating an employee and they're being let go, or maybe an error in drawing up the employment agreement, which somehow makes that employment agreement unenforceable. And so I just want to make one tweak before we talk about claims here, is that there's a kind of a gray area in skilled trades. And so what I would say there is qualified trades are obviously professionals in what they do. But where we don't consider the professional liability is because of all of the hands-on nature of their job. So for example, a plumber clearly is a professional, but that work is actually hands-on in doing what they're doing. And so that's not a professional liability versus a bodily injury or a property damage. So we're going to see those examples as we move into other areas, but I just want to clarify that that's not a part of what we're talking about here in professional liability. So let's move on to professional claims. A presentation that I did earlier in the year on cyber and privacy liability, the overwhelming feedback I received was that give us claims, and more claims, because they help giving us context. So throughout this presentation, we're going to be looking at a lot of different claims. And this is our first one in the professional realm. Despite 50% of our clients being professional services, we don't actually see a lot of professional claims in our office, but the first two of the claims we're going to look at here were actually in our office. And in the case of this architect who had a claim, the insurer in this case stated that the client's documentation, their file work product, helped to settle the claim more favorably than had that work not been as complete as it was. This started off as a multi-million-dollar claim that the client was named in along with the engineer and the project manager and a variety of other professionals were brought into the suit. But in this case, like I said, the client's file notes actually produced evidence of other parties' work product, and the architect's insurer was therefore able to negotiate their way out of this multi-million-dollar suit a little earlier than everybody else. So clearly it's not my intention to read the screens for you. So I'm going to have a little pause, but I just want to make sure everybody has a chance to take a look. This worked out to over $300,000 clearly. So for our second claim, this was another client in my office. And in this case, the clients contracted restricted claims that their clients could bring to them to the cost of their fees and the hardware only, which significantly assisted in getting the claim resolved quickly. In this case, a $500,000 demand letter was received. However, the client felt that their client knew behind the scenes owed lots of money to the IT firm. So the client felt that this claim was brought in order to avoid paying a bunch of outstanding fees to them. So on our end, I'm only able to confirm that defense costs only were paid. However, the client could have also agreed to have written off some of their outstanding billings. I'm not actually sure on our end. We only see the defense costs that were settled, but no actual loss payment was made to this third party, despite a $500,000 demand letter received. And I forgot to change the screen again. There we go. So this is the IT one where the $500,000 demand was made. Okay, claim number 3. I pulled these ones from an insurer that we dealt with just to give you a variety of different kinds of claims. It's said that in insurance, a main consideration of kind of transferring risk in the professional area is that the defense costs alone can put small businesses out of business. And the reason why is that it can take a long time to actually defend a professional liability claim. So for example, that architect and engineer claim that I brought up earlier, that was like 4 years of defense costs. And in the IT one, that was only a few months at this point, I think, as to getting that claim resolved. But the defense costs still can be a lot of money, even if it's a few months. It can be tens of thousands of dollars. In this case, this was a printer, and there was a delay in them doing their work, and it's just a simple loss that would happen, I'm sure, but it was a big deal for this particular retail store owner. All right, and our fourth and final claim here in this particular area is another case of allegations of negligence and failing to perform the job that was contracted for. And again, it's just simply that a lot of us understand that we can be busy and pick things up and put things down. And there can be different time restrictions on when we need to get things done. And in this case, the building owner sued the property manager and had not only for failing to maintain the building, but they had also successfully lost clients and lost lease income from those clients. So this too ended up to be a big claim. So the big topic here is risk management. And this is a really important area that actually will apply to everything else that we're going to talk about today as well. So one of the most important things that I think is a professionally drawn up contract. This is really key to everything that you do in your business, and it's so important. So my recommendation is that you spend the money up front for a good lawyer to draw up a good contract, ideally limiting your company's liability wherever possible. And then for as much as you can, make sure that that contract is utilized for all of the contracts wherever possible. And adding into that contract is making sure that you have a really complete scope of work added to that contract. If you choose to transfer some of your professional liability risk to an insurer, most insurers will want to review a copy of your contract up front and even ask you what percentage of time or what percentage of the contracts do you use this contract on. And insurers will stress over and over again that if the worst happens, it is much harder to defend you if there is nothing in writing. And so perhaps some of you have even experienced this now in your own businesses and where you're working, is that a client comes back after the fact where something has gone sideways in a project and the client wants their money back or they refuse to pay, and you're then able to refer back to the terms of your contract and hopefully resolve that issue a little easier. However, I find that your contract should not only include the scope of the work that you're doing, but equally important can be to outline what isn't included in your contract or in the project scope and what is available, additional services that you might offer, but it's available for an additional cost. This makes a really thorough point that a client can't come back and say, well, you didn't do this, that was part of the scope. If you have a list that says this is what is included, this is what isn't included, this is what's available for an additional cost, it's pretty difficult for a client to argue that you didn't do your job properly. So the second key point of risk management for professionals especially is this document everything. So whether it's your emails, your phone calls, your change orders, and a final sign off. I will have conversations with clients and they really like to be able to do business on the phone and come to agreement. And I'm okay with that. We do that too. But the key, therefore, is then to send a follow-up email of summarizing that conversation and making sure that the understanding between the two of you is the same. And that, therefore, puts that onus back on the client to come back and say, not after the fact, but once they've received your email, oh, that's not what I understood. This should also mean this. And clarifications are there. And if they don't come back to you and you've sent a summary of what your understanding was, it's a lot easier to defend yourself for those purposes. And at the end of the project, it's really important to get a final send off or even a final email that goes out with your bill of, to the best of our knowledge, this is now complete. We've done these things. If you don't agree and something is still outstanding, to let us know. That can be really important to defend yourself after as well. Of course, all of this only applies if you can use your own contract. And the bigger the clients you deal with, the less likely you're going to be able to use your own contract. And so, sorry, I was like, oh, did I change the screen? So if you have to sign someone else's contract, this also should be looked at really carefully. And ideally, it should be somebody who's experienced in reviewing these third-party contracts. I like to keep an ongoing list of what I see in the contracts, what should be reviewed, and keywords that you're looking for to indicate a problem. an idea of which areas you want to be able to negotiate. And this gives you and the person who's doing this a good idea of when you need legal assistance to review your contract. Because I get you don't want to have a lawyer review every single contract, but also where you want your insurance broker to review the insurance terms and conditions as well, because that can really change. You'd be surprised the number of times that I hear from a client after they have signed the contract and they need the certificate of insurance, and I send it over to them and they're like, oh no, this won't do, it's failed. They won't pay us. We've already done the job, but we needed insurance at different limits. And so this causes a lot of issues, obviously. And sometimes if we're not reviewing the clauses in those contracts, the changes can be thousands of dollars to comply with the insurance requirements. Or worse, if your particular insurer won't agree to the terms of the insurance terms in that contract, that can suddenly have to force you to remarket your insurance on a rush. Your premiums might go up substantially. So generally, I recommend a more proactive response of looking at the insurance provisions specifically before you sign a contract to know if you can negotiate those things. And my example would be that if it's $2,500, a $2,500 contract, but it's going to cost you $5,000 in increased insurance, then you're going to clearly be comfortable in walking away from that project. But if you've got a $250,000 project or a $2 million project, and it's a $5,000 or maybe even a $25,000 increase in your insurance, at least you know, and you can either negotiate with your client about the terms of that, and you can either negotiate it down or negotiate that they'll pay a portion of those fees, but at least you know what those things are before you've signed that contract. Because I have to tell you, after you've signed the contract, it's a lot more difficult. So that's really my big deal for risk management here. And we're going to take a little pause and check in with Jamie if there's any questions we should address here in this section.
Hi, yes, for sure. Thanks, Andrea. A couple quick questions. So one that came through was, how common is it to have limit liability in a contract cost of service?
Very common.
And you would
very
common that then?
Yeah, very common, and in fact recommended. So yeah, a lot of contracts that we see will be the cost of fees, right? And that's really the main reason for you to make sure you have your own contract, is to limit your liability. If you think about it, when you're signing somebody else's contract, those terms are never going to be to your benefit, right? So you always want to use your contract wherever possible, and have your contract lawyer limit your liability wherever you can.
Yeah, and especially when you're the one providing the product or services, right? Because
yeah,
it's mostly your obligation when it comes to the contracts. I think that's great advice. But to the point that you made, the bigger the client, the harder that advice is to follow.
Right. And that's why the bigger the client there, that's why it's really important that your scope of work, therefore, be as detailed as you can with the project terms, what's included, what's excluded from the scope. Yeah, that can help a lot.
So, question that came up when you were going through the different cases, and I'm going to tell like a very quick, funny story, partially because it's funny, but also because it reminded me of the moment. So, okay, back when I was a kid, I grew up in Saskatchewan, which is SGI. For those of you that don't know, that's no fault insurance for driving. So I was very young, and I worked, and I had my own money. And in more than one case, I got into teeny tiny accidents and chose to pay the deductible because I could afford the deductible, as opposed to just living with a dent or fixing my car. And this was a major point of contention with my parents and I. The funny one was that my ex-boyfriend, who they had no use for anyways, drove up to me when I was parking at a Subway because he happened to be driving by and saw me. So he skidded into the parking lot, drove in right as I was opening the door. And as I was opening the door, he crushed my entire car door. And so that one absolutely needed to be fixed. And he pulls me aside and he's like, I don't actually have my driver's license right now. So like, I need you to make this claim and I'll pay for it all, etc. And so my parents and I got in so much fights about this because I was like, well, I'm just going to pay the deductible. He'll pay me back. I'll take the fault. What's the big deal? You know, rewind the story forward and I moved to Alberta and I literally could not afford insurance for the first 3 years of living in Alberta because my driver's record was so ridiculous. But the worst part of it is about 50% of that was me being a terrible driver. And the other 50% was making deductible choices that my parents did not support or agree with. So now I sit here and I'm always under the impression, and I literally had a conversation about this morning with my business partner, Jesse, that I almost under no circumstances would I pay a deductible and use my insurance because I got burnt so badly from paying the deductible, using the insurance, and then having an insurance bill that I couldn't afford, that I kind of look at as insurance as something that I have to have in order to get through the contracts. But the likelihood that I would actually pay a deductible and use insurance is really, really, really low. And that's partially because I've been burnt. So I guess my question is, whether it's personal or business, I think it's kind of similar. Like, what is your advisory as the broker to people about like how to not only when they should pay a deductible and not pay a deductible, but in the decision making of getting the insurance, thinking about like, would you actually pay the deductible and use the insurance anyways? And how does that all factor in? And what's the conversation that you'd have with someone? Because at the end of the day, you know, if I'm not going to pay the deductible and use insurance, then I should minimize my insurance, I would think. But I'm also a CFO with a bias. So
right.
Would love to hear from a professional.
So that's a really big question. And as almost like a lawyer, as an insurance broker, I would say that depends. But I would say it really does. If we limit that question to professional liability, even then I would say that the answer depends on the size of your company. So if your company is small, and by small in professional liability, we're talking about gross revenue, then deductible options don't really save you a lot of money if you're small. But the larger the company, the more revenue you have, deductible options can significantly save you money. And then you can have that discussion with your internal team of what amount of a deductible are we willing to assume as a company before that insurance kicks in. And that will look different for every company. Is that $2,500? Is that $5,000? Is it $10,000, $25,000? Is it $50,000? And so the bigger the company, the more options you have in that deductible option being flexible and saving you money. Because that's true, right? That it is true that that there can be, you wouldn't use your professional liability as a deductible issue. Like if you're just having a fee dispute with a client over whether they're going to pay their fees and that kind of stuff. If it's really small, you wouldn't use it for that. But within your company, you want to look at how much are we willing to pay before we implement that and take a deductible accordingly. And maybe it's $10,000 and you've been in business for 5 years and you're able to take that premium savings and over those courses of the year. The other thing I'll suggest to companies, if they're taking, if it's really worth the deductible savings, like maybe the deductible difference between a $10,000 deductible and a $25,000 deductible is, let's say $5,000 a year. Well, why don't you just put that $5,000 a year into a separate account and hold it there? And after your 3 years, you've made up your deductible, right? Difference in deductible, and you're making money after that time. So it depends circumstance on on the kind of company and the size of company and the operations of the company, because that can vary too as to whether your company is deemed less risky or more risky. And that's just based on frequency of claims in the industry that you're in.
Yeah, and
So,
I think like what I love about your answer is, well, it advocates for that financial modeling and forecasting that we stand by. Like essentially that's
right.
what you're saying is
Yeah.
forecast it out and
Yeah.
what's the loss, what's the deductible, and then that kind of gives you your answer.
Yeah.
The hard part about that forecast is the increase to your insurance. Like, so what if I was to do a forecast, if I make a claim, is my insurance going to go up like 10% because I made a claim? Like it's already going to go up because of inflation and economy and all this other stuff. But the making a claim, what would be a reasonable number to put in my forecast that because I chose to make a claim, my insurance is going up by X?
Well, there is a little bit of a difference here between personal lines insurance and commercial insurance. And typically in commercial insurance, you don't really, only in the odd occasion do you get renewal discounts or anything like that, where if you have a single claim, you're automatically going to go up 15% because you've lost a claims-free discount. Most of the time that doesn't apply in commercial. And so sometimes you'll find that you have a claim in professional, and unless it's major, even if it's major, your premium doesn't go up extraordinarily, right? So for example, in the case of an architect, having a $350,000 claim didn't mean that their premium tripled or anything. It still may have only had a 10% or a 15% increase. The insurers recognize that you've been paying on this insurance for X number of years, and they also know that there's no way for you to make that money up, right? But it's a pool in insurance. So I wouldn't say that that having a minor claim or even a major claim will automatically increase your premiums up more than usual. You might end up with an inflationary increase normally of 3 or 4 or 5%, but maybe after a claim it might be 15%. So it's hard to balance that, but
yeah.
And
I guess
again,
with business, within the growth,
it will. Yeah, so sorry, I just wanted to maybe finish that up by saying it will depend on the type of policy as well, right? So there will be a difference on your directors and officers policy versus your professional policy versus your commercial general, right? They'll all be looked at differently, and there's no real set answer for that. But
there is a question from the members on D&O insurance. So they're asking, what's the likelihood that a company's D&O would cover someone who's acting as a de facto officer because of the nature of the work they're doing?
We're going to cover at the end on the directors and officers, so maybe we can address that at the end. Yeah. But I would say that that's about the company declaring their intent to the insurer, right? A lot of things can be covered as long as you make that clear in your application process of what you're trying to cover.
Awesome. All right, let's head back into it.
Okay, so our next section is going to talk about injury to others. So we're going to split this part into two sections of bodily injury and emotional injury. And from there, as this slide shows, we're going to break those allegations into allegations from what we would call third parties to allegations from employees. So we're going to look at those differently as well. So to clarify, a third party is anyone other than you and maybe your spouse and your employees. So somebody who's separate from your organization, and then bodily injury to employees here. So bodily injury to third parties is typically what we would be most concerned about as business leaders. Are our clients and our participants safe? And claims arising from third parties or employees typically revolve around these few things: your physical space, your actual operations or your products, and from your people. So injury to third parties can occur because of your people as well. So another type of allegation that could come from third parties or volunteers is what I would call abuse liability, which would more revolve around, instead of bodily injury, but a physical injury or sexual abuse types of allegations. And finally, mental or emotional or sexual abuse claims. You know, we might consider things like class actions that we've heard about for the clergy, maybe consider prolonged abuse in our residential schools, consider coaches in sport organizations, or even the coaching team at, you know, USA Gymnastics. Or these types of claims might take years and years and years to come out, but they're more likely to come out in today's world than ever before, as we all know from our media today. So the question is, how do you defend your company or nonprofit from these kinds of allegations? So let's take a look at some sample claims here. So I pulled these ones all from the news. So these claims are relatively easy to understand as we hear about them in the media. And it can be anywhere from spilled coffee causing a burn going through the drive-through at McDonald's to a trip and fall on ice or a curb. I had a call last week for a client where a guy was on his phone and tripped over a curb and then started a claim for the client because they can't take any personal responsibility for themselves. Okay, cynical, sorry. But also consider things like elder abuse or the alleged neglect in care centers where our seniors are can be left, or consider other people that might walk away from a care center, you know, somebody with dementia or something like that. A common call I get after we've placed liability insurance for someone is actually an injury to the owner or partner themselves, which that's not liability insurance, that's not negligence, right? Our common liability insurance are negligence based. And so an owner getting hurt is not something you can't sue yourself in your business. And as a practical example, I'll tell you that last year I had a spouse of a business owner for a landscaping business, and she went out to a site to collect a late payment from a client. And while she was there, she kind of stepped on an apple and she fell poorly, and it caused significant damage to her leg. No doubt about that. She was seriously injured, required surgery, had extended disability time, but she called because she wanted to sue her own company for her injury. She couldn't work because of all the pain and the injury. So she did have workers' comp, which in effect prevents you from suing your employer. And additionally, she was also on the EI injury, short-term injury type of collecting those payments. But she decided that wasn't enough. It wasn't replacing her income still between the two of them. And they had no supplementary disability coverage. So she was bound and determined in multiple phone calls with me that she was going to sue her own husband's company, which she was actually the management of. He didn't really have anything to do with the company and operating the company. So I can assure you that those conversations did not go all of that well. As I had to explain to her that you effectively can't sue yourself. All right. A different kind of injury claim is what I would call recall claims. And these are about failure of your product or your product liability, which can cause an injury or make people sick. And so those are that's if you have a physical product that people are ingesting or using and it causes an injury. And there's definitely many examples out there that we hear again in the media. So let's move on to some simple risk management in bodily injuries. And again, I would say contractual liability is important where you can. And we sign a variety of contracts as business owners and leaders, from leases to our vendors to contractors. And we can always try to limit our liability in those areas. But also in a lot of contracts that we see, those third-party contracts actually try and transfer other people's liability to us. So one of the things we need to be aware of is trying to limit assuming the liability of others. And in my opinion, everybody's in business and they should be responsible for their own negligence. But quite frequently, the contracts that we see try to get our businesses or our clients to assume the liability of others. And if you have participants or where people are actually involved in participating in your product or service or whatever, or even volunteers, a good option there can be to have waivers as well. But there are a lot of pieces to having a waiver stand up. So that's really important to get a good waiver and have that reviewed. But you don't have to reinvent the wheel for those things. There are a lot of waivers out there that you could come up with a waiver, customize it, and then get some legal assistance. And risk management for bodily injury for employees, I would say, again, with employees, it's really important to have proper employment agreements with respect to abuse. If they're working within your company, you're going to look to have performed your due diligence before hiring this employee, right? You've done your police checks, your reference checks. There's other things that you can do. But also internally, we're going to have key policies and procedures that need to be updated regularly. Something like an abuse policy of if a client notifies one of your employees that maybe their child was hit or they think they were abused, what are the reporting procedures within your company? Do all of your employees understand what the reporting procedure should be? And if that allegation is actually against the person who's responsible for being reported to normally, then what's the secondary course of reporting? So there are a lot of internal procedures we can have for those kinds of losses. So again, I'm going to pause here briefly and see if there's any quick questions, hopefully quick, on the bodily injury, because I want to stay conscious of the time here.
Yeah, the only question that has come up is defense fees. So obviously in most of these situations, lawyers are involved. Yeah. If you pay the deductible and use your insurance, are the defense fees fully covered?
Yes. Typically, yes, defense fees, regardless of the policy. There's two ways of that being handled, depending on the type of policy that you're purchasing. In a lot of cases, your defense fees are as a part of the limit that you chose. So if you have a $2 million commercial general, your defense fees are taken out of that $2 million, and any award is of the difference. In policies like your professional liability, that's similar. Your defense fees are included in the limit that you choose. But in other policies, like maybe directors and officers and that, your defense fees can actually be outside the limit of insurance, which makes it a really good option. Sometimes that can happen in professional liability as well, but each insurer is different and each policy is different through the different insurers. But yes, I would say that defense fees are typically covered. And in fact, you can take that one step further, that if we consider something like abuse for a nonprofit and abuse liability, there might be a sublimit there of $250,000 for abuse, and it might only be defense fees because insurance intent is not to cover criminal acts. So it's going to defend the company and pay the defense fees. But if there was a court award, it's not likely going to pay that. So in principle, I would say yes to defense fees being included in the cost of your insurance.
All right.
Okay.
Got it.
All right. Let's move on to this section of injury to others, which is more allegations from third parties for emotional and other types of things. So this is libel, slander, humiliation. Sometimes in public, we can roll our eyes and go, oh, yeah, I was upset and I'm humiliated over these things. But in some cases, there are real cases where, I was reading online on an article yesterday about a mother posting that her son had been tackled to the ground by a security guard at a Safeway and searched and choked and such like that. So there really is kind of false arrest type of claims and discrimination claims, and these things are real. And there's other online exposures to our businesses with the libel, slander, defamation. If we are not careful, or if our employees are not careful and we slander one of our competitors, or make allegations that our competitors don't handle things properly, our businesses can be held account for those things. And on the employee side, it's very similar, that within our business, if we're not dealing with bullying, if we're not dealing with people who are yelling and humiliation, and or if we've terminated someone, and that's a common thing that I see in some of those statements of claim, is that the prior employees are alleging loss of reputation because it's becoming known in the industry that they were let go for specific purposes. So if our people involved, if our management and directors and our key staff are opening our mouths when we shouldn't, we can definitely be held to account for those things. So let's look at some specific claims in this area. So I pulled these ones. Obviously this week, there's been a lot of press over the defamation award against Kevin Johnston, our former mayoral candidate. I would say that this is pretty usual and obviously extreme from what we might see. I don't think I've ever had a defamation or slander type of claim in my office. And a lot of times that coverage is kind of rolled into the commercial general as an extension. So it's not something you have to go out and buy specifically. However, the publisher's liability or your social media liabilities, those can be a little different. But the next two claims here, I'm certainly well aware of. So claim number 2 is in our office currently with a current claim. This is actually the second claim for this particular client in the last couple of years. And I would qualify there that it's important that if you're letting someone go, and if there's a settlement for something, that be locked down, that information be locked down, and try not to have it be passed through the company. Because if it's passed through the company, then others become aware of the fact, well, all we really need to do is contact a lawyer and send a demand letter, and I can increase my severance and benefits and those things. So it's really important for risk management purposes to lock down those types of things when you're letting people go. And claim number 3 is someone who's in my business community, and it's almost tragic what's happened here for this particular associate of mine. So there is some debate and some articles that I've read that say with the tight labor market, the amount of wrongful dismissal and constructive dismissal and those types of claims should decline, because it's going to be harder to argue that people can't go get replacement jobs. That's not what I'm seeing. And I think that maybe the differential there is maybe that depends on the level of type of job that you're getting. So I think that's different for executives, that it becomes a reputation thing, and that the higher up in the chain in the organizational chart that somebody is, the harder it is for them to get a replacement well-paying job. And so I think that we continue to see more claims in that area for higher up executives. And with respect to this claim number 3, I'm guilty of this too. Hindsight is 20/20. Sometimes we want to make a point, and sometimes we want to be able to say, no, I'm not going to be taken advantage of here. I'm not going to have the screws twisted on me. But the reality is, regardless of the facts, these types of claims do not always go our way as employers or as business owners, regardless of the strengths of our case. So it's really important to have a realistic, hard talk with an employment practices lawyer about the reality of winning this case, how long it would take, and versus the severity of the loss, and whether it's important to get out of the claim early. So yeah, that was particularly, as you can see, the numbers involved, 4 years and $350,000 in defense costs later. And this was not insured. There was no insurance for this particular company. So let's talk risk management for employees. And I know we've addressed this again before, which only goes to kind of reinforce that when a suit happens, it's typically multifaceted. So the job of a lawyer when bringing a suit is to bring make a bunch of different allegations. And insurance coverage is all about the allegation that's being made. So when a demand letter or a lawsuit is filed, you'll see that it has a number of different allegations. And so those allegations could easily fall into a number of different areas. It might fall into an emotional injury type of claim. It might fall into financial losses. It could even fall into abuse types of claims. So it's really about all of the different allegations that are made. But risk management is still always the same, making sure that you have an employment agreement that is reviewed occasionally with current claims, right? It can't be static. It has to be a living document. And also internal policies and procedures, making sure we have employee handbooks are updated. Currently, we might have new policies and procedures on how we might deal with cannabis in our employment agreements, or technology use types of agreements. We have to keep those as living documents, and they have to keep changing. And it could be that what happens is when you go to give a raise or a bonus or change, that's the ideal time to change your employment agreements. Make sure that it's been updated, that it's got enforceable termination clauses, and that the new types of requirements are there. But again, using someone who's a specialist in those areas is important, and they may not need a whole lot. If you have an existing good document, then to tweak it and bring in a couple of new policies may not be that significant. So I will say that, as in all, there's a saying out there that you either spend it up front to handle it properly, or you spend more down the line when you have to pay for a loss and then have your contract or document updated again anyways. So let's pause here real quick. I know we're at 1 o'clock, so we might even skip property damage and go right to directors and officers, but let's see what there is for claims here.
So I know I specifically told you we don't want to spend too much time on cyber, but as one would expect, we have a question on cyber.
Yeah.
Can save it for later or ask it now?
It doesn't, cyber is just kind of in the periphery of what we're talking about here, but sure, throw it at me.
So the question is really about, obviously the premiums are becoming so high with cyber, and we've even had presenters come on to AHA and come into Amplify and suggest that, you know, the availability of cyber insurance is limited and they would be willing to put money on it not even being available in 5 years. What are your thoughts on cyber? I mean, I think there's certain businesses out there, and Amplify would be one of them, where we have to have cyber insurance just based on our CPA rules and expectations of clients. So we have cyber insurance for contractual reasons and compliance reasons. But if you're a company that has no contractual or compliance reason to have cyber, would you think it's a good investment, or are the premiums and the ability to use it just not making it an investment that covers real liability and risk?
Right. Okay. So I would say that cyber is still widely available. It still can be relatively economical. We still see some policies that are under $1,000 a year. There are still add-ons to different areas where you can add cyber onto existing policies. Like if you're a professional, you can add cyber extensions to your professional liability insurer dependent, and that's still generally affordable. But what I do think as a qualification there is that where cyber is changing dramatically, that makes it, that's making it whether you can afford it or not, are your internal tech security and policy and procedures. So what we're seeing more and more is that the insurers are having a minimum kind of requirement of these are the policies and procedures that need to be in place for us to offer you insurance. And so that's actually really good risk management information, which I'm going to address a little bit further. But so, for example, what we're seeing on the quotes that are coming out right now is that if you don't have dual factor authentication enabled, you don't get quoted, right? Now, that's not overly hard to do in most cases, but if you don't have it, you don't get a quote. So a lot of times your insurance brokers have resources. Like I have a pamphlet right now from one of the key cyber insurers that we use that says, these are our minimum requirements for security that we require if we're going to quote it. And they're fine, and they want us to send this out to prospective clients. So ask your insurance broker, what are the risk, what are the resources that you have available, and then consider those internally. Can we implement them? And in some cases, if things can't be implemented, that's your broker's job to work with you and in some cases the IT firm, to explain why that can't be implemented and provide that information to the insurer. And if we can provide a good case for that, then in some cases those restrictions are overlooked. But no, I'm not having any problem actually getting cyber insurance yet for anybody, with the exception of maybe managed services companies are pretty tight to try to IT managed services, right, to get coverage for them. But in principle, most other companies, I'm not sure that we're seeing any restrictions on that. But the value adds that the cyber insurers are now bringing to the table are really important. Like they're bringing handbooks, they've got requirements on employee trainings and a variety of resources. So cyber insurance is still really, in my case, I would say still reasonable. And if you're not required to have it contractually for dealing with particular clients or with your associations, then you can choose smaller limits. You don't have to go with a 2 million limit. You could go with a $250,000 or a $500,000 limit, which makes it more affordable.
That's great. And I love the value add opportunity that we probably all have, and have an advisor that can hand that to us. So that's a great
cyber.
That's great.
Cyber for sure. There's a lot of value add right now from the insurers, but also even in, for example, these areas with wrongful dismissal and employment practices, on your directors and officers policies, they'll typically have like an HR assist legal helpline that you can phone them and talk to an employment lawyer and get assistance before you go and terminate somebody. And that's all included in the price of what you're paying. So that's one of the things I'm going to talk about again below, is what resources you already have that you're not actually utilizing. So I think what we're going to do is just go really quickly through property damage, because it's relatively simple as far as that goes. It's one of the easier ones. So this is, that you have caused physical damage to someone else. So relatively simple to understand. This is where I was saying those trades come into it. So your plumber and your electricians, HVAC contractors. This is where there might be faulty workmanship type of claims. But also there can be things like if you're other risks, like if you're a storage company and you're storing customers' goods, you could be responsible for those goods. So that's kind of a warehouseman's. But the vast majority of property damage losses that we might see would be really simple, like a fire in your premises expands and also damages your neighbors. And that you can be liable for that. Or water damage from your kitchen sink or your dishwasher causes a leak and causes damage in 3 other units. Again, those can be liability losses. So we'll just quickly take a look. I'll maybe highlight this one claim that I had in my office, which was so unfortunate for these guys. These are all losses within my office. I didn't have to go outside of them. But in one case, we had an arborist where there was a labeling error on a container, and the employee thought that they were injecting a fertilizer, and they actually injected a herbicide and killed some very expensive trees on multiple different client sites. That was a huge loss. So other than that, if you loan or rent equipment, then you might be responsible for that equipment. And there's different ways of covering that you need to talk to your insurers about if that's high valued equipment. Otherwise, you can self-insure that. And again, on that cyber piece, we had an IT consultant that they were accessed through a client site and locked down, and then the hacker gained access to other of the IT company's client systems as well. And in some cases, the client systems were damaged. So sometimes that's a liability exposure. It's called property damage, but it is you're liable for somebody else's damages. All right, so risk management here, there's lots again of resources out there. If you talk to your insurers or your brokers, and I would also recommend talking to your community. These types of things in particular, you don't have to reinvent the wheel in order to come up with policies and procedures to put into place. So we're going to skip any questions here and make sure that we have some time in kind of a key area. So hopefully that's all right with everyone. So our final area that we're going to talk about today are allegations of mismanagement of the company itself. So sources of legal action, there's a list here of where you can get claims from on the company itself. So regardless of the size of your company or the different types of operations, there can be legal obligations owing by the company or the owners or the directors or management of a company. You can be responsible for your actions or your inactions. And so let's take a look at where do those claims kind of come from. So a lot of times it's about misleading representation or neglect, breach of your duties. And the government can still come after you personally for unpaid taxes. There can be shareholder disagreements, conflict of interest allegations, breach of debt covenants, and failure, right? If you have shareholders and you fail to meet your financial obligations, there are ways for those kinds of allegations to come as well. But nothing speaks louder than words in this case, or than claims. And in this case, I've chosen 4 claims to kind of show you some different examples on. So all 4 of these claims have been given to me by one of our directors and officers insurers. And this one was fairly big. And I wanted to kind of talk a little bit about the exposures in mergers and acquisitions. This is a growing area of directors and officers claims, is mergers and acquisitions, or selling and buying out partners and that. So I would say the only real claim in directors and officers other than employment practices claims I've had in my office was a number of years ago when a nonprofit board was taken over with a hostile takeover of another board. So a group that wanted to come in and take over, they didn't like the way the organization was being run. There was a couple leaders of it, and they arranged for other people to come in, and they basically took over the nonprofit. And it ended up with court injunctions and board against boards. And by the time the original board got back into the association, it was a little bit decimated. So there was no money left. Money was unaccounted for, and was spent in areas that they weren't, their nonprofit was not really supposed to be spending money in, and things like that. So that was a fair size loss a number of years ago. But we've already kind of addressed the employees, so we won't talk about employment practices anymore. But this is kind of a subsidiary one, obviously, where the purchaser found after the fact. This is confusing to me a little bit, because with something this size, there would have been all sorts of professionals involved already. There would have been lawyers on both sides, there would have been accountants on both sides, there would have been due diligence for something this size. And yet, this was a massive, massive claim. Okay, so on this one, an Ontario-based manufacturer, this is where I was saying that directors and officers can be held personally liable. Directors of your company can be liable for up to 6 months unpaid wages and taxes for every single employee. So this is why there are a lot of people out there who will not agree to sit on boards, or at a minimum insist on there being a directors and officers policy of adequate limits in place before they do so. Obviously, the bigger the company, the riskier the operations, the more controversial the company, the bigger of limits you would need in directors and officers types of coverage to feel comfortable if you're putting your own personal assets on the line. And in these types of cases, he or she who has the most assets actually has the most to lose, because ability to pay doesn't matter to the court. So if I have $250,000 in assets and Jamie has a million, and we're sitting on the same board, and it's a large loss, Jamie may have to pay her $1 million in, and I pay my $250,000 in, and then Jamie has to come back at me personally to collect the rest of my share. So this can be really a difficult area for directors and officers of companies. So here's a third claim we're going to talk about quickly. I'm just going to give you, this one's a little easier to understand. It was just that they'd made a contractual agreement, And then that clearly was broken in reassessing where their money had to go. Maybe it's hard to know what went on behind the scenes. Did they get legal advice about breaking this contract, or what happened? We're not entirely sure. But suits can come out of these things, and in this way, the racing team sued them as well. And finally, this one's kind of interesting. I wanted to show, how about a family-owned business with shareholders? It's all owned within the family, but only the members who work within the business had any voting rights. So between the shareholders, we now have a lawsuit. And I guess my tongue-in-cheek response is that, you know, nothing brings a family closer together than suing your other family members to try and get out of your business. So that was kind of interesting. So we're not really sure at the end here what the settlement was, or whether they had to buy them out, or what the case was, just that the legal fees were paid by the insurer. Okay, we're running out of time, so let's make sure we're good. So risk management then. I want to give you just a kind of a simple risk management process about try to make sure that you look in each area of your business, whether it's your accounting controls, your occupational health and safety, your liability exposures, those kinds of things is really important to take a look in all areas of your business, but also to involve everybody where it's warranted, have different people involved in your committee to look at it, because groupthink becomes real. A lot of times when our management team is working together, we're all on the same page, where we can sometimes think the same way. And that really doesn't do us a lot of good when we're looking at risk management. We want people who look at things differently to be involved in the process. And so I would say again that there's a lot of information that you can ask for your insurance broker. If you're considering a different kind of list or a different kind of risk, ask your broker for specific claims examples. Ask them if there's any specific requirements in order to obtain insurance in that area. Ask them for an application. Ask them if they have any tools or handbooks in those areas. So I want to kind of point out that applications and identifying specific requirements that are needed to obtain insurance is a great way to start to minimize your risk. And just a quick example there is in your accounting controls, if you were trying to obtain crime coverage, the application would ask you, are your checks duly signed? Well, the reason the insurer is asking you that is because there are claims in that area where only one signature was needed, right? So if you take a look at the applications that are there, and consider why those questions are being asked, it's typically not only to find out more about your business, but to address key areas where there are claims. So that's a good place to start with what processes and controls does the insurer consider meaningful and that maybe you could consider in your business. So a couple quick tips here that this can seem really overwhelming, I'm sure. I mean, I'm a business owner too, and we always have lots of balls in the air and areas to spend our time. But this goes back to what I'm saying, you know, kind of break it into smaller pieces, consider the ones you want to address the more quickly, and maybe even have some low-hanging fruit, things you can do quickly. And it's always good that you kind of consider, what have your competitors faced? Or if it's not an industry specific issue, what can you learn from other types of losses out there? And then again, like I talked about, trying to either have an advisory board of different people who run different kinds of businesses or are involved in different things, or that can be super helpful. And in summary, my key focus as a broker, that a main thing you can do contractually is, the main thing you can do risk management wise is controlling that contractual liability and keeping a handle on that. Somebody should be responsible to oversee it. They'll gain more and more experience in it. They know what they're looking for. It becomes less time consuming. And also they become familiar with, when do I need to get that clause looked at by our lawyer? When do I need to get that clause looked at by our insurance broker? Internal policies and procedures are really important, and you choose what's important for you. Employment practices is one that will apply to everybody except for kind of one-person, two-person operations. Employment agreements and quality control of how their jobs are being done, and those types of things are important. Transferring risk where you cannot control or you cannot predict the amount of risk should be considered, even if it's at higher deductibles. And ask your community for resources and your insurance broker. I know I've said that 3 times. There's a reason for that. We have a lot of resources. And finally, utilize specialists where you can, especially in the more key areas like employment practices and your contractual liability. You don't have to use them all the way. You can come up with the basis of what you need and then run it past them so you can kind of control your costs. And that is it. Thank you. I'm not sure if we still have time for any questions that anybody might be interested in. And that's it.
Sure. If anyone has any final questions, please do let us know. That was great. I love the fact that there's things you can do to improve your business that will also set you up for better opportunities when it comes to insurance. So that was a great ending point, and a lot of those tips are within the control of the people that we've got joining us today. So that's awesome. Thank you, Andrea, so much. We'll be sure to send out the slides and the video for those of you that need to revisit or share it with a friend. Please make sure that you do that. Again, we'd love to have you join us on the 3rd Tuesday of May and June. May we'll be talking with Amplify Tech on some hot topics in the tech world. June we'll be doing personal branding. Then we take the summer off. You'll have lots of time to visit our podcast and YouTube video, then lively entrepreneurial talks with Amplify. And we'll be back for AHA in September, along with a live event to be announced soon. Thanks so much for joining us today. And thanks, Andrea, for your support. I appreciate it greatly.
Yeah, thanks for the invite. Bye, everyone. Thank you.
Awesome.